right now for a campaign jab against then candidate Donald Trump has now made it all the way to the Supreme Court.
That issue is whether the phrase Trump too small can be trademarked.
And joining us now to explain all this for us is our Queen City News legal expert, Khalif Rhodes.
All right, Khalif, so how did we get here?
You got to look back to 2016. I mean, this is very interesting. You got Mark Rubio at the time, former President Trump, then candidate Trump was calling him Little Marco, and so he took issue with that. And at a rally, he said, well, he may be taller than me, but I'm, he's 6'2". But why does he have hands that are the size of someone that's 5'2"? Then he paused. He says, well, the crowd, what they say when people have small hands? The crowd erupts in laughter. He says, well, you can't trust them. That prompted the individual to file a trademark application. That trademark application was denied. U.S. Patent Office said you can't do that. And so then the guy took it to the Court of Appeals. The Court of Appeals said, well, actually, he can do that. And so then now they take it up to the Supreme Court and they granted cert. And so that's why we're here today.
You mentioned grant cert. What is that also? But what we see out of this too is that
what's going on? We are back with another breakdown episode, and this one that's actually a juicy one. Who are we talking about? The 45th president. Was he the 45th or the 44th? I think it was the 45th president of the United States, Donald J. Trump. As the gentleman, the bald-head gentleman just talked about, this situation arose back in 2016. The Supreme Court, which we're going to pull up that publication where the Supreme Court just recently ruled on the issue. But again, this started in 2016, as the gentleman talked about. It was a presidential debate between Mark Rubio, Republican out of Florida, as well as Donald Trump. And I guess, hey, look at Donald Trump told little Rubio. And I'll take offense to that, man. I'll feel some type of way if you call me Little Rubio. But anyway, Mark Rubio came back and said, hey, man, you're 6'2". Yeah, you may be taller than me, but you got small hands for somebody that size. And you know what they say about somebody that has small hands. So that's pretty much the back and forth. So then you have this. Actually, this gentleman is an attorney who out of California. He's, I think, an environmental law attorney. He says, you know what? I can make some money off this. So he goes and start selling shirts, which we'll pull up the shirt that says Trump too small. He also files for a trademark application for the phrase Trump too small, so that he's the only one that will be able to sell shirts with that on there. And kudos to him. Seems like he's an environmental lawyer, so nothing dealing with IP, but kudos to him for trademarking that, because otherwise everybody could have been able to start selling shirts with Trump too small on it, Trump too small on it. So the fact that he was looking to protect that phrase so that he was the only one who can sell shirts. And the USPTO, United States Patent and Trademark Office, actually rejected the gentleman. They said, hey, man, you can't do that. And I'll pull up the reason why, because he needed permission from Trump, because Trump essentially is a public figure. So if you are and again, this is the learning lesson, because I'm trying to kind of give you guys not only entertainment with these videos and these breakdown reaction videos, but also some trying to give you guys, add some value to you guys' life. So if you are trying to trademark a phrase and it has someone else who's a public figure, if their name, whether it's the first name, whether it's the last name, whether it's a nickname, it's in that phrase such that people in the public will know who you're talking about, then you have to get written permission from that said person. So this rule actually saved Donald Trump. So obviously you're talking about Trump too small, and it has the gesture of the small, the hands right there. People would know, they would have known that he's talking about Donald Trump in that scenario. So essentially the USPTO, given Section 2C of the Lanham Act that governs trademarks, they're saying, hey, you essentially have to get Trump's permission for us to be able to, because they said they didn't find anything. So they were going to allow him to get a trademark on that term outright, but kind of given this Section 2C, they said, hey, man, you got to get Trump's permission first. And obviously we know Trump is not going to give him permission for that. So the gentleman, he said, man, this is bull. So he appealed it. He appealed the decision of the USPTO to the Court of Appeals. The Court of Appeals agreed with them. And then, interestingly enough, which the article is going to say, Joe Biden actually appealed this thing on behalf of, I guess, Trump, if you can say that, or the USPTO, but it was in favor of Trump, appealed this to the United States Supreme Court, which we all know they get about 8,000 petitions essentially a year, and they only grant 80 of them to listen to them. So you're talking about 1%. So they granted this situation or this petition, and they ultimately ruled against the lawyer who's tried to trademark Trump too small. So that's essentially what is happening. We will let's get off into the article here that was on, I think, what is it? MSNBC. We'll go through that article really quickly, and or NBC News. So Supreme Court blocks Trump too small trademark bid for referring to crude joke. So again, and this is another interesting thing. even though, again, we're talking about penis size and all that stuff, if this was did 5 or maybe 10 years ago, the USPTO, they would have blocked it because you couldn't have immoral or scandalous or those type trademarks. You couldn't try to protect those type trademarks. But because the fact that the Supreme Court essentially overruled that, given the First Amendment, now you can, the Trump too smalls and these kind of more so scandalous or immoral terms or phrases or pictures, logos, you can't get those trademarks. So USPTO didn't reject it under that because they couldn't, given the situation, the Supreme Court's ruling back in, I think, 2017, but they kind of used this Section 2C of the Lanham Act to say, hey, man, everybody knows you're going to be you're talking about Trump with this trademark, with this phrase, Trump too small, so you have to get permission from him. So that's essentially what is going on here. Let's read the article here. So Supreme Court blocks Trump too small trademark bid referring to crude joke. And this was hot off the press, June 13, 2024. What's today? June 17. So this was last week, end of last week there. So Supreme Court on Thursday rebuffed a California lawyer's attempt to trademark the phrase Trump too small, a reference to a crude joke made about former President Donald Trump. The court ruled unanimously, that's crazy, in favor of the USPTO over its decision to reject the applicant brought by Steve Elster. So Steve is the attorney out of California, the environmental law attorney, who is looking to capitalize off, I guess, Trump's misfortune, you can call it. So in doing so, the court tossed out a ruling by the U.S. Court of Appeals for the Federal Circuit. So I told you guys that before. The USPTO ruled against the attorney who was looking to trademark the term. He appealed. The Court of Appeals ruled in favor, saying, hey, man, this is this goes against his First Amendment, and therefore he can trademark the term without having to get authorization or consent from Trump. And then the Supreme Court ultimately granted cert, and they overturned the Court of Appeals. So moving on here, Elster said in an email the ruling was disappointing but not unexpected. So he figured it could have went this way. And plans to continue to sell T-shirts bearing the slogan even without the trademark. So again, this is an interesting part. So he plans on continuing to sell the T-shirts having the Trump too small phrase as well as the logo there. And this is a good point that I want to make sure you guys understand. Just because you can't get a trademark on something, as long as you're not impeding or infringing on somebody else's trademark, you can still use the term. So in this case, again, like I said before, Trump too small, the USPTO would have granted him a trademark if he got authorization or consent from Trump. But since we all know Trump is not going to consent to this, he can't get a trademark on it to protect it, to keep others from using it. But he himself can still use it. But again, what's the other side of that? Everybody can use it. I can use it. You, the audience member, you guys can start selling shirts with Trump too small on it. So he can't kind of, I guess, protect or exclude others from using this phrase if he wanted to. And so that's the downfall of it, but it still seems like he's going to nonetheless still use the mark, which is that paragraph is saying. So Justice Clarence Thomas wrote on behalf of the court that restrictions on people trademarking certain names do not. That's weird. Justice Clarence Thomas wrote on behalf of the court that restrictions on people trademarking certain names do not violate the Constitution's First Amendment. The law in question is of peace with a common law tradition regarding the trademarking of names. We see no reason to disturb this long-standing tradition. So they said this goes back a while ago, which supports the restriction of the use of another's name in a trademark. The Trump too small phrase is a reference to a crude joke we talked about Senator Marco Rubio out of Florida made about Trump back in 2016, the presidential primary campaign. Rubio joked about what he said, where Trump's small hands, adding, and you know what they say about guys with small hands. I haven't heard that one in a while, though. Elster, an employment lawyer and progressive activist, so we all know this guy's a Democrat, it seems like, applied to register Trump too small, a double entendre meant to insinuate corresponding small, hold on, small what? With the trademark office in 2018. So this has been going on a while. He filed for a trademark back in 2018. It's 2024. So this was kind of 6 years in the making. And it seems like this guy, he took this thing all the way up to the Supreme Court. So the slogan appears on the front of the T-shirt. So this is the shirt. Let me blow this up so that you guys can see it here. Hopefully you guys can see it. The slogan appears on the front of the T-shirt. Trump too small, like I said, with the hand gesture there. And then on the back is kind of talking about his package. So it's actually a pretty kind of clever, I think, way of saying, okay, Trump's package is too small, talking about his package, but also talking about from a political standpoint, they're talking about small on environment, small on civil rights, LGBTQ, immigration, workers, voting rights, affordable. And this is actually interesting because he need to update his shirt because it seems like small on immigrant. Well, I guess he's immigrant rights. I mean, I guess this is accurate. Healthcare. Although some, I guess, may say that he kind of does more than Joe Biden in some of these areas. So this is on the back of the shirt here to the right. To the left here is the front of the shirt that says Trump too small with the actual hand gesture. Elster said in his application that he wanted to spread a message that some features of President Trump and his policies are diminutive. But the trademark office rejected his application on the grounds that members of the public would immediately associate the word Trump with the then president. Under established law, Trump's written consent would be required, the office concluded. So again, this is what I was telling you guys from the beginning. And again, let this be a learning lesson to all of you out there who's looking to maybe monetize off someone's not necessarily misfortune, but a clever phrase or whatever the case may be that's associated with someone else. If that someone else is famous, or like is famous and the public can know that you're talking about that famous person, then you're going to need their written consent. So hopefully you guys kind of take that away from this particular breakdown video. Again, before you start going out trademarking phrases and things like that, if it's dealing with talking about another famous person, then you're going to need that consent. So that's that. Hopefully you guys, what you guys think? Let me know in the comments. Do you guys agree with the Supreme Court? Do you guys disagree with the Supreme Court? Do you think this is a First Amendment issue? And regardless of whether or not you are calling into question or criticizing someone who may be famous, that you should still be able to get the trademark on it. I actually kind of like the fact that you can't just trademark these different phrases going after, I guess, famous or publicly, public people without their consent, just because it can start kind of getting a little, I guess, gray area-ish when you're talking about kind of coming up with some things that can be derogatory, even though we know, like I said, derogatory trademarks are not, they can still be protected or trademarked, which I'm all cool with that. But then when you're kind of talking about somebody else and then you got families and stuff like that involved, kids and spouses and all that, being able to see those things, and I think it's kind of starts to get into a slippery slope there. But again, this is the law. This is the news. Let me know in the comment section. Do you guys agree with the Supreme Court? Do you guys disagree with the Supreme Court? I tend to maybe agree with the Supreme Court in the long-standing tradition as it relates to this. But again, let me know if you guys disagree, and be sure to hit the like button if you guys enjoyed this type of content. I'll try to kind of bring you guys more of these kind of current events. I know with I guess the presidential season here coming is about to ramp up. I wouldn't be surprised if it's more of these type lawsuits, hopefully from an IP standpoint, so I can kind of break them down and comment on them and add some value to you guys. From that, please hit the subscribe button if you haven't already. Definitely looking to hit the notification button as well, so that you guys can continue to get notified of this type of content. I try to drop these once, twice, 3 times a week, as there's a ton of stuff going on the IP front out there. And yeah, so until next time, you guys take care. Peace.